Hello Live Law viewers, you are aware that every year we bring you a compilation of 100 important judgments of the Supreme Court. I am your host Urvashi Chauhan, and this year again I am here with landmark judgments of the Supreme Court in the year 2024. These are judgments important to the general public or have settled a contested position of law or are useful for practicing lawyers, judges and students. I will tell you in brief about the judgment. We will display its citation and title also for you on the screen. For detailed reading, you can always check out our website at www.livelaw.in. Remember, the 100 judgments will be covered in 4 parts. This is part 1. Let's get to our set of 25 judgments in this part. Starting with Vishal Tiwari versus Union of India, where the bench of then CJI D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra refused to order a probe by a special investigation team or the Central Bureau of Investigation into the allegations leveled in the Hindenburg research report regarding stock price manipulations by the Adani group of companies. The court had refused to accept the reliance placed by the petitioners on newspaper reports and the report of the Organized Crime and Corruption Reporting Project to doubt the SEBI investigation. The court had also ordered SEBI and the investigative agencies of the Union government to probe into whether the loss suffered by Indian investors due to the conduct of Hindenburg research and any other entities in taking short position involved any infraction of law. Next, a bench of then CJI D.Y. Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra in the case of State of Uttar Pradesh versus Association of Retired Supreme Court and High Court Judges framed a standard operating procedure on the summoning of government officials and directed that all high courts should follow it. It was held that all high courts should consider framing rules to regulate the appearance of officials after taking into account the SOP. Next is the case of Bilkis Rasool versus Union of India, where the Supreme Court bench of Justices B.V. Nagaratna and Ujjal Bhuya set aside the remission of 11 convicts sentenced to life imprisonment for multiple murders and gang rapes, including that of Bilkis Bano during the 2002 communal riots in Gujarat. The court held that state of Gujarat was not the appropriate government to decide the issue of remission, as the trial was held in the state of Maharashtra. Since the Gujarat government was found to be incompetent, the remission orders were held to be invalid. Accordingly, the court directed the convicts who were given premature release in August 2022 to surrender in prison within 2 weeks. Taking note of the dismal rate of grant of compensation under the scheme formulated by the central government for the victims of hit and run accidents, the Supreme Court in the case of S. Rajashekharan versus Union of India issued a slew of guidelines. The bench of Justices Abhay S. Oak and Pankaj Mithal also suggested a revision of the compensation amount of 2,50,000 for death and grievous injuries respectively arising out of hit and run cases. Moving ahead, the Supreme Court in Shama Sharma versus Kishan Kumar passed a general order directing that the caste or religion of parties shall not be mentioned in the memo of parties of a petition or proceeding filed before the courts. The judgment was delivered by a bench of Justices Hima Kohli and Ehsanuddin Amanullah. Justices Abhay S. Oak and Ujjal Bhuya in State through CBI versus Naresh Prasad Agarwal quashed a judgment of the Madras High Court on the sole ground that the judge released it after retirement. Observing that a judge retaining the case file after demitting office was a gross impropriety, the bench remitted the appeal to the High Court for its fresh consideration. In an important judgment delivered in Chandigarh Housing Board versus Tarseem Lal, the Supreme Court held that a person with status of scheduled tribe in one state cannot claim the same benefit in another state or union territory where he or she has eventually migrated, where the tribe is not notified as ST. In a significant ruling, a constitution bench of the Supreme Court overturned its 2018 Asian resurfacing judgment, which mandated interim orders passed by high courts staying trials in civil and criminal cases will automatically expire after 6 months from the date of the order unless expressly extended by the High Courts. The top court in this case also issued guidelines regarding the procedure to be followed by High Courts in passing interim orders of a stay of proceedings and dealing with applications for vacating such stays. The title of this case is High Court Bar Association Allahabad versus State of Uttar Pradesh, and the bench here comprised of the then CJI Chandrachud and Justices Abhay S. Oak, J.B. Pardiwala, Pankaj Mittal and Manoj Mishra. In a landmark decision in Sita Soren versus Union of India, a 7-judge bench of the Supreme Court overturned the 1998 P.V. Narasimha Rao judgment, which held that members of Parliament and Legislative Assemblies could claim immunity under Articles 1052 and 194(2) of the Constitution for receiving a bribe in contemplation of a vote or speech in legislature. In a detailed ruling, the Supreme Court has now emphasized that the purpose of these Articles 105 and 194 of the Constitution is to sustain an environment where debate and deliberation can take place within the legislature. This purpose, the court noted, is undermined when a member is induced to vote or speak in a particular manner because of an act of bribery. In yet another important ruling, a 5-judge bench of the Supreme Court held that anonymous electoral bonds are violative of right to information under Articles 19(1)(a) of the Constitution. Accordingly, the scheme has been struck down as unconstitutional. This was the case of Association for Democratic Reforms versus Union of India, and the quorum was the then Chief Justice D.Y. Chandrachud and Justices Sanjeev Khanna, B.R. Gawai, J.B. Pardiwala and Manoj Mishra. A bench of Justices Abhay S. Oak and Ujjal Bhuya significantly quashed a criminal case against a professor for his WhatsApp status criticizing the abrogation of Article 370, describing it as a black day for Jammu and Kashmir. This was Javed Ahmed Hajam versus State of Maharashtra, and the court emphasized the need to sensitize police officers about fundamental rights. In Dablu Kujur versus the State of Jharkhand, the bench of Justices Bela M. Trivedi and Pankaj Mittal observed that police officers submitting the police report or charge sheet to the magistrate as per State Police Manual shall abide by particulars of Section 173 subsection 2 and directed the officers in charge of every police station across the country to strictly comply with the mandatory requirements of this section of CRPC. The court said, failing which it shall be strictly viewed by the concerned courts, that is where the charge sheet or police report is filed. Now gain in-depth insights and interpretations of significant rulings and legislative changes all in one place, absolutely free with Live Law Premium. Access multiple digests including subject-wise and topic-wise Supreme Court digests on CPC, Constitution, IPC, CRPC, evidence, etc. plus annual High Court digests. Plans are starting at just 1099 plus GST. Visit livelaw.in to subscribe now. Coming to the case of Rakesh Ranjan Srivastava versus the State of Jharkhand. The bench of Justices Abhay S. Oak and Ujjal Bhuya here observed that mere filing of the check dishonor complaint under Negotiable Instruments Act would not grant a right to a complainant to seek interim compensation under Section 143A, subsection 1 of the NI Act, as the power of the court to grant interim compensation is not mandatory but discretionary and needs to be decided after prima facie evaluating the merits of the case. In an important judgment, the bench of then CJI Chandrachud, Justices J.B. Pardiwala and Manoj Mishra held that there cannot be any discrimination between the retired High Court judges depending on their source of elevation, whether from the bar or the district judiciary, while computing their pensionary benefits. The title of this case is Ministry of Law and Justice, Union of India versus Justice Raj Rahul Garg. Next, the bench of Justices A.S. Bopanna and P.S. Narasimha in the case of Apurva Arora versus State quashed the pending criminal case of obscenity against the makers of web series named College Romance. Reversing the findings of the Delhi High Court, which had refused to quash the obscenity case against the lead cast and makers of the web series, the bench held that vulgarity and profanities do not per se amount to obscenity. The Supreme Court, in its verdict in Navas versus State of Kerala, recapitulated certain factors that the courts considered while deciding convict's period of sentence before remission could be sought. These factors included the nature of injuries, the number of deceased victims, the criminal antecedents of the accused and also whether the crime was committed while the accused was on bail. The judgment was delivered by Justices B.R. Gawai, K.V. Vishwanathan and Sandeep Mehta. In a significant judgment, the Supreme Court in the case of Devuji Nair versus State of Kerala issued guidelines for the High Courts in dealing with habeas corpus petitions or petitions seeking police protection. The guidelines come as a consequence of a petition filed by a woman against a Kerala High Court order, which, while considering a habeas corpus petition, directed her alleged lesbian partner to undergo counselling. The bench of CJI D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra, in issuing the said guidelines, observed that such directions for counselling often torment the members of the LGBTQ+ community and could have deterrent effects. Moving ahead, Justices Abhay S. Oak and Sanjay Karol in Noble M. Paikada versus Union of India set aside an amendment that eliminated the requirement of environmental clearance for extracting the earth for linear projects such as roads, pipelines, etc. The court termed this blanket exemption completely unguided. Based on this, it was held to be arbitrary and violative of Article 14 of the Constitution. In Kari Khokri versus Nune Tayang, Justices Anirudh Bose and Sanjay Kumar, while holding that candidates contesting elections are not required to disclose each and every movable property owned by them or their dependents unless they are of substantial value or reflect a luxurious lifestyle, upheld the 2019 election of independent MLA Kari Khokri from the Tezu Assembly constituency in Arunachal Pradesh. The court held that every defect in a nomination filed by a candidate contesting elections will not make the nomination invalid. Only defects of a substantial nature, which can impact the outcome of an election, will render the nomination invalid. Every non-disclosure, irrespective of its gravity and impact, would not automatically amount to a defect of substantial nature. Next is the case of Association of Democratic Reforms versus Election Commission of India. The quorum here was Justice Sanjeev Khanna and Justice Dipankar Datta, which rejected the pleas seeking 100% cross-verification of electronic voting machines data with voter verifiable paper audit trail or VVPAT records. The court observed that suspicions regarding EVM tampering are unfounded and reverting back to the ballot paper system as prayed would undo the reforms that have taken place over the years. Coming to the case of Dolly Rani versus Manish Kumar Chanchal, where the bench of Justices B.V. Nagratna and Augustine George Massey emphasized that for a Hindu marriage to be valid, it must be performed with the appropriate rites and ceremonies such as Saptapadi, 7 steps around the sacred fire, and proof of these ceremonies is essential in case of disputes. The court emphasized that Hindu marriage is a sacred institution and should not be trivialized as a mere social event for song and dance and wining and dining. The Supreme Court in Shoma Kanti Sen versus State made a crucial observation that the apex court's findings in the Gurvinder Singh versus State of Punjab case would not disturb the ratio arrived in the landmark case of Union of India versus KA Najeeb. Both these cases relate to grant of bail in UAPA cases. Taking note of the importance of submission of a charge sheet to take cognizance of an offence by magistrate, the Supreme Court bench of Justices Sanjeev Khanna and S.V.N. Bhatti in Harif Ahmed and others versus State of Uttar Pradesh observed that the charge sheet must contain clear and complete entries of all columns to enable the court to understand which crime has been committed by which accused and what is the material evidence available on the file. And now talking about Achin Gupta versus State of Haryana. In this case, raising serious concerns about misuse of Section 498A of the IPC proceedings against the husband and in-laws by the wife, Justices J.B. Pardiwala and Manoj Mishra requested the Parliament to bring out necessary changes to the new IPC or Bharatiya Nyaya Sanhita 2023, which contains provisions such as Section 85 and 86 akin to Section 498A of IPC. And in Anis versus the State Government of NCT, the Supreme Court noted a lack of thorough cross-examination by public prosecutors in criminal appeals, specifically with hostile witnesses. The court here said that prosecutors often only confront them with their police statement, aiming to highlight contradictions but not fully explore the witness's testimony. So that is all from part 1. Stay tuned with me for part 2 of this series, where we will cover the next 25 judgments and map their impact on our jurisprudence. Please do not forget to like, share and subscribe to our channel. You can also comment and tell us about your views.